was your fourth Chief Justice of the Supreme Court. But in 1800, I was serving in a different capacity. I was Secretary of State, which, as you all know, means I just answer all the phone calls that come in from North Carolina. Well, perhaps I had a few more jobs than that. I served under John Adams. Well, in about 1801, something rather unfortunate happened with Mr. Adams. He lost an election to an absolute terrorist, Mr. Jefferson. I have disdain for Mr. Jefferson. He was an odious person. Well, John Adams, in his infinite wisdom, just before he left, he enacted something that has come to known as the Midnight Judges Act. What he did is he expanded the power of the courts at the last minute, just before he left office. He had one more thing he had to get done. And he appointed a number of judges, created a number of additional circuit courts in an attempt to keep Mr. Jefferson from doing too many odious things in office. Well, another thing that he did during this time frame, he appointed a number of justices of the peace. We all know what justices of the peace are, correct? Well, they do the local level things. Fairly important, generally speaking, in our day-to-day lives. I believe we would probably call them district court judges now, I suspect, something to that effect. It's been a while since I've walked the earth, so perhaps my modern terminology is a bit off. I was brought in through what I can only describe as the power of Mr. Lewis's necromancy. I was quite content in my grave. However, it is rather important that we learn about these things. Regardless, before Mr. Adams left office, he also appointed me as Chief Justice of the Supreme Court, which was a post that I had turned down a number of times in the past, but at this point I thought, well, someone has got to stop Mr. Jefferson and his foul plans, so I accepted. However, something questionable happened. The commissions for these justices of the peace, you see, not all of them were delivered in a timely manner. Some of them mysteriously disappeared. They were delayed a bit. And in 1801, I took my post as Chief Justice of the Supreme Court. Now, as we all know at this point, the Supreme Court was not what we think of it as today. The Supreme Court was not quite as powerful as it is today. It was, how would you describe it, Mr. Lewis? It was
impotent.
It was, yes, that's a good word for it. It was impotent. Well, before long, Mr. Marbury, William Marbury, one of the individuals who was assigned one of these commissions, he was to be one of these justices of the peace. And as you all know, this is somewhat of a cushy job, you might describe it. It was a lot of sitting around in very comfortable chairs, far more comfortable than the chairs everyone else had. And the salary was quite nice, probably more than I made, although I have no way of verifying that. I just have my suspicions. And Mr. Marbury really wanted his commission, but unfortunately he was one of those individuals that did not receive his patent, his commission to start his job, right? It was a non-firm job offer, so to speak. Well, Mr. Marbury, in his infinite wisdom, sued. He sued because Mr. Jefferson, in his terroristic ideal, ordered Mr. Madison, the man who took my previous position, he ordered him to find these commissions and refuse to deliver them. Right? He did not want these justices of the peace. He did not care for the virtue of Mr. Adams. He disliked Mr. Adams. As we all know, he was an odious man. So, Mr. Marbury thought, okay, well, how can we deal with this? And he looked and he looked and he looked, and he found a federal statute passed in 1769. Wait, no, 1796, I believe it is. He found a statute that allowed him to bring a case directly to the Supreme Court. Now, if you want satisfaction, where would you find it? Well, you would go to the highest court in the land, impotent or not, Mr. Lewis, impotent or not. You would go to the highest court in the land, and you would ask that court, you would say, force these horrible individuals to do what was promised. And this Judiciary Act did say that the Supreme Court could not only have original jurisdiction over such cases, which means, of course, we hear the trial level case, correct? Not only that, but the Supreme Court could then order elected officials to carry out their required job duties, which, as we know at this point, Mr. Madison's required job duties were to deliver the bloody patents, the commissions, to Mr. Marbury. So he sued. And he waited, and he waited, and he waited. 2 years he waited. And in 1803, my court, impotent though it may be, heard the case. Marbury versus Madison. Mr. Marbury demanding the satisfaction of his nice cushy job. Before that, I believe he was pumping gas. Demanded his commission. And we considered his case. And do you know what we found? We found that he had every right to have his commission. It was legally ordered, appointed by the virtuous Mr. John Adams, and illegally denied by the horrible, horrible Mr. Jefferson and his odiousness. Well, what happened? Do we think that Mr. Marbury got his cushy job? Oh, I would have loved to give Mr. Marbury his cushy job, but unfortunately, I had to look at the Constitution. The Constitution grants the Supreme Court, the impotent Supreme Court, it grants us no authority to order elected officials to carry out their duties. It grants us no authority to even hear such cases. So, what should I rely on for purposes of this case? Should I rely on the Constitution of the United States of America or a federal rule? Which one do we like better? Oh, surely we have an answer to that. Yes, 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 exactly correct. The Constitution of the United States. And a federal rule cannot go in and overrule the Constitution. It can't add to the Constitution. It can't take away from the Constitution. We have methods to deal with that type of thing, although they're unpleasant. Right? A federal rule. So, what did we do? We said, Mr. Marbury, we're quite sorry. You absolutely do have a legal right to your commission and your cushy job. But we can't give it to you. The case must go away. We can't hear it. We don't have jurisdiction to hear it. And even if we did, we have no authority to tell Mr. Madison, even though he is but an agent of the odious Mr. Jefferson, we have no authority to tell him that he must give you your commission. And so his commission rotted. And for the remainder of his life, I believe he pumped gas. That's true. I'm sure he got some other cushy job, but I lost track of that. However, something was accomplished by this. We established something that day. We established something that made Mr. Jefferson cry delicious, delicious tears. Figuratively. Although, I'm not convinced it wasn't literally. He's an odious man, and he had a temper. We established a particular concept that you may be familiar with.
review.
We established judicial review. That is absolutely correct. We put a bit of vigor back into the court. No longer impotence now. We established the precedent of the Supreme Court evaluating all legislation to decide whether it's constitutional or not. Somebody had to do it, did they not? We can't have legislature coming in and passing laws willy-nilly to say, oh, we'll do this, don't do that, just based on what we feel like. No. We have to stick to what the Constitution says. And so, by doing so, the power of the Supreme Court was expanded exponentially. In fact, some might argue that the Supreme Court is now, as a result of this seizure of power, the 9 most powerful people in the world. Because legislature can do what legislature would like to do, but can they do things outside the Constitution? No, they can't. And up until now, who had been the decider of what was constitutional and what was not? Well, the answer to that was President. Well, do we really want one man, especially when that man is an absolute terrorist and an odious human being? Mr. Jefferson. No, of course not. We don't want that. Now we have 9 men, and that power has endured to today.
Marbury versus Madison is a key, and I hate to say it, I am nowhere near as entertaining as he is, and I fear that I've just totally been upstaged. And he has better hair, even if it is fake. Nonetheless, Marbury versus Madison is one of the most important Supreme Court rulings of all time because of this concept of judicial review. What it establishes is that the Supreme Court gets to look at the law and compare it against the Constitution and say whether the law is legal or not. And we're going to find that through this, over the years, we've had many amazing protections and rights that have been granted to us. Just in the last few years, some of the rights that have been protected by the Supreme Court, private gun ownership, for example. We've had 2 cases that have gone through in recent years. And just in the last, this past session, this summer was an amazing time for the court. Some of the most important issues we've seen lately. Many of you are familiar with the fact that same-sex marriage has been deemed protected under equal protection under the law of the 14th Amendment. We've also determined that states must provide health care subsidies according to the Affordable Care Act, also known as Obamacare. And another one that I'm not sure many of you have heard, there's a question of freedom of speech and social media. How many of you heard about this case? Alonis? All right, a couple of you. Essentially, there was a guy, I forget which state he was in. He is a budding rapper who, after breaking up with his girlfriend, put some rap lyrics on Facebook, songs he was working on, that described violent acts against an ex-girlfriend. Supreme Court ruled that, that social media releasing an art form does not constitute a threat against an individual and is protected as free speech and art. So, there you go. Okay, but just because the Supreme Court rules on it, I have a little surprise for you. That doesn't necessarily guarantee that it is law. I'm going to go ahead and put this out there, and some of you may be surprised to hear this, but just because the Supreme Court rules in a case doesn't make it right. I'm going to tell you now, Supreme Court gets it wrong every now and then. And some of you right now are probably thinking, boo, I understand. Please hold your fruit, rotten fruit until later. What's that? So why would I say such a thing? Very simple. Let me go ahead and start with my, straight from the home office in Wahoo, Nebraska, the top 10 worst Supreme Court rulings. I'm actually not going to give that to you. I won't give you 10. I am going to give you my top 5, though. And I'm going to talk about all these in a little bit of detail. Number 5, Plessy v. Ferguson, a case from 1896 in which the Supreme Court ruled that separate facilities being equal is constitutional and segregation is therefore legal under the law because the 14th Amendment allows for equal protection under the law. It doesn't matter if they're separated as long as they're equal. Thus, the court ruled in 1896. Number 4, Korematsu v. United States. This is a World War II case in which there is a question about President Franklin Roosevelt's Executive Order 9066 allowing for the internment of Japanese Americans based solely on their ancestry. Case number 3, Dred Scott v. Sanford. Those of you in my U.S. history class, we're going to talk about this in a lot more detail. But essentially the court ruled that they didn't call them African Americans at the time. They said persons of African descent are not guaranteed the rights, are not recognized as citizens, and therefore are not guaranteed the rights of American citizens. How many of you have heard of all 3 of these cases? Okay, my top 2 are ones I'm willing to bet money most of you have not heard of. Number 2, Kelo v. City of New London, Connecticut. How many of you have heard of this one? We're going to talk about this in a little more detail, but essentially this was an eminent domain case. I'll give you full details in just a moment. And number 1, another World War II case, Wickard v. Filburn. Has anyone heard of this? Beth and I. Okay.
I'm married to a historian, remember that.
I am so sorry. Wickard v. Filburn. Okay. This is a case, and let me tell you why I have these up here in this order. These 3, 5, 4, and 3, these have been corrected. The last 2 have not, and that's why I still put them as worse, because they have not yet been corrected, because, well, we'll see why in a minute. So, I'm going to break these into 3 categories. The first one I'm going to talk about are the 2 cases that have not been corrected, and why I think it's such a horrible decision of the Supreme Court. First case here, Wickard v. Filburn, is equal protection under the law. Japanese internment is not a violation of due process, not a violation of habeas corpus. Executive Order 9066 is all hunky-dory. However, as time passes, 1954, Supreme Court rules in the case of Brown versus Board of Education, separate is not equal. We have a rehearing of the Japanese internment issue, and we see that it was overturned in 1983. What happened? What changed? Years? Yeah. Did the law change? Did the Constitution?
Interpretation.
No. None of this changed. All that changed were the years. But something had to change. You don't go from, I hate it when that happens. I was not looking and I was supposed to have the X come up and yeah, all right, that was embarrassing. Okay, but something happened. I thought it was up a few moments ago. Okay, so something changes from separate but equal to separate is not equal. Something changes from this is not a violation to it is a violation. What changes? The simple answer, the interpretation of the court. Those 9 justices who are sitting on the court, as Mr. Marshall told us earlier, these 9 people in their infinite wisdom change how they interpret the Constitution. So, how does this happen? I want to give you a couple of tools and check the time. Okay, I'm going to try not to be too terribly much longer. Let's talk about how it changes. There's 2 main theories on how we interpret the Constitution. One is known as a liberal constructionist view, and another is a strict constructionist. I'm going to kind of outline these and think for yourselves. How do you fall? How would you interpret the Constitution? If you were in a legal case, how would you interpret it? So, a liberal constructionist tends to believe in a looser interpretation of the Constitution, giving it a broad spectrum of possibilities. Typically, we hear the phrase a living constitution, and we tend to call it a living constitution in this theory because we believe that the intents and the meanings of the Constitution naturally change over time with the changing ideals of society and the morals of the nation. You have strict constructionists who believe in a much more narrow interpretation of the Constitution. They look more so at the original intent of the founders, the people who wrote the Constitution. And the other thing is they focus a lot on exact phrasing of the Constitution. And if you don't like how it's phrased, if you don't like, we have the Fifth Amendment, or not the Fifth Amendment, the Fifth Article, which allows us the opportunity to change it. You don't like it? Change the Constitution. And so these are the 2 viewpoints that you tend to have. And looking at it today, we have 2 justices on the court I'm going to talk about very briefly These are like the two rock stars of the court today that are very well known for their opinions. A great example of a liberal constructionist is Ruth Bader Ginsburg. And for your strict constructionists, Antonin Scalia. These two people are both loved and hated for their viewpoints. They are perhaps more well known, more so than anything else, for their dissents. When they disagree with the opinion of the court, they will write some of the most scathing dissents you've ever heard. Antonin Scalia has actually been the subject of various books because of his dissents, and Ruth Bader Ginsburg, thanks to her initials, has come to be known as the notorious RBG. Folks, I highly recommend go read some of their dissents, and you will just be you'll be amazed how polite and official they can sound while tearing someone to pieces. It's amazing. And if the same question goes before the Supreme Court in 1995, do you think that the Supreme Court would have ruled the same way? I personally don't think so. So I actually had this debate last night with someone I was talking on the phone with while I was driving home, talking about what I'm doing today. And she said she thinks the Supreme Court would have supported it, but even 20 years ago, I think that they might have used full faith and credit, which is in Article 4, Section 1 of the Constitution, which says, Congress may, by general laws, prescribe the manner in which such acts and proceedings shall be proved and the effect thereof. In other words, I think that they could have just as easily said, this isn't protected under the 14th Amendment, this is allowing states to define, and we, by general law, DOMA, law passed by Congress, a general law, say that they don't have to. And so there are ways, and my point that I'm trying to show is that in different times, in different societies, we can interpret the same questions very differently using different parts of the Constitution. Now, I think the big question here, why do we care? All this discussion about the Supreme Court, why do we care? And I'm trying to take a different angle because I'm hoping you see the Constitution, well, not just the Constitution, but the Supreme Court in a way you've never seen before. Why do we care? Because let's just imagine. Let's put on our pretend hats. Griswold v. Connecticut, a famous case from 1965, it interpreted that Americans have a right to privacy in the 9th Amendment. How many of you read the Constitution? Where do you find the right to privacy in the 9th Amendment? Anyone know? There's the 9th Amendment, the whole thing, word for word. The enumeration, or spelling it out, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In other words, what we have here is the Supreme Court saying, well, nothing in the Constitution says there is no right to privacy, so you have it. What if they look at it and say, you know, we get some 9 new justices who want to be different in their interpretation and say, you know what, Griswold is wrong, this does not give us a right to privacy. What would that change? Let me throw out one for you. You know what would change? Roe versus Wade. It did not say you have a right to get an abortion. Roe v. Wade simply said that laws preventing abortion are not the state's business because pregnancy is a private issue between a patient and a doctor. That was decided on the right to privacy, not constitutionality of abortion. I'll throw out one more and then I'll shut up. Imagine if the case, LDS Church versus United States, so-called Mormons, they used to practice polygamy. There were a series of laws that were passed making polygamy and bigamy illegal. They go to the United States government, they sue, saying that their religious liberties are being denied. And what does the Supreme Court rule? The Supreme Court rules, and I quote, or polygamy was, quote, a crime against the laws and abhorrent to the sentiments and feelings of the civilized world. It is contrary to the spirit of Christianity, close quote, and therefore it is not protected under the Free Practice Clause of the First Amendment. Could we not have a case where someone goes and sues and says, it is my right to marry as many people as I want, as long as we are consenting adults, why not? We want to claim it under religious liberties. Could you see, I personally can, I could see this being overturned because the Supreme Court's whole ruling is not the Constitution, but this isn't how we define Christianity. Could we imagine a court ruling that today? Probably not.
Well, how does that go against the Establishment Clause in the First Amendment?
Well, the Establishment Clause and the Free Exercise Clause are very close, because when you look at the two side by side, he's good question here. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Congress isn't saying, hey, we are a Christian nation. That's not what they ruled here. And I know some of you got into the class, I understand, I'm sorry. But what they're ruling here is also antithetical to the concept of free exercise. All right, ladies and gentlemen, before all of you just run out, let me close this. I had a couple more things. I obviously ran out of time. I had a game show thing. But I do want to just ask, are there any questions before we depart? Any questions at all? Even if it's about how bad my tie is. Yes, Dr. Griffin.
I guess I often wonder how outside public opinion can influence the way the courts rule, because they usually kind of, it seems like they follow what they think most Americans want.
I think that unofficially it has more impact. There's a lot of outside influences that do impact the court. One of the most well-known is the 1937 court packing plan from Franklin Roosevelt, who, there's still a debate as to whether or not the court changed naturally or if that coercion did force them. Who was it? It wasn't Kennedy. Was it Souter, who a few years ago said in a dissent, he asked, why don't we use international law more often in our interpretations? Was it Souter or was that Kennedy? All right. So, yeah, it'd be kind of, but Kennedy's kind of your, we don't know where he's going to fall. He's your swing vote most of the time. So the thing is, we do have a lot of outside influences that affect how they interpret. And what's usually surprising is when we have a justice that we know for fact is going to vote one way. I'll give you a prime example. The original law questioning Obamacare, everybody knew that John Roberts, the Chief Justice, was going to vote against it. And the question was, how is Anthony Kennedy going to vote? Well, Anthony Kennedy, the so-called swing vote, he actually voted against it, but the Chief Justice, John Roberts, voted for it. And everyone was like, yeah, and so we don't know what happened there that affected his decision.
The attempt to limit that as much as possible is the lifetime appointment of judges. The thought process is that they're appointed for life, they cannot lose the position no matter what they do.
And so they don't have to worry about politicians.
So they're supposed to be immune to politics and immune to outside influence as a result of that. It's not perfect, obviously, but it does have to be. Imagine what it would be like if they had full return.
And be reappointed.
It would be problematic.
Suddenly you start voting the way the president, if you want to get their job.
You start getting political votes.
Yeah.
Some legal analysis.
So I guess it's not really how well qualified you are that gets you on the court.
No.
It's all about politics.
As a matter of fact, what's interesting...
To get you appointed, to some extent, yeah, that's pretty accurate.
What you have to understand is when you look at the first article that outlines the legislative branch, 10 articles, it's about, depending upon how it's printed, usually about 4 or 5 pages long. Article 2, defining the executive branch, the presidency, it's about 2.5, 3 pages long. The third article, which defines the parameters of the Supreme Court, 2 paragraphs. It doesn't have any requirements. The only requirements to be on the Supreme Court, President Obama walks in this room, looks around and says, you look like a fine, upstanding young person. I'd like to nominate you for the Supreme Court. And if approved by the Senate, she is now a justice for the rest of her life. That's all it is. It is nomination and approval.
They all are, but you don't have to.
You don't have to be alone.
It's terrifying, isn't it?
However, what we have found today is, unless you have stood in front of the court arguing, it's very, I can't think of anyone other than people who have been lower court judges, who have worked their way up as judges. But you typically find lower court judges and people who have argued cases before the Supreme Court. That's almost exclusive where they come from today. That hasn't been the history.